Okay, they'll give you an attorney if you haven't got one. So what they're saying is Mr. whatever his name is bringing the claim against you. But because he hasn't got the money, the state on behalf of him is bringing the claim against you. But because we're all equal under the law, you equally are entitled to state representation. So both of you are on equal footing. Nobody's prejudiced. Okay? So in that, then you do show where's the harm? What actual harm has been done?
But if we're all equal under the law, can I not get the CPS to represent me? Now it's a nullity because it's CPS versus the CPS.
No. The state will, you have the right to state representation. Okay? The CPS is just basically a prosecution service on behalf of the people. Anybody that's allegedly harmed. Okay? But you equally, under the law, or legislation even, you have the right that the state provides you with a legal representative if you're stupid enough to get one.
Were you charged?
Pardon?
Were you charged?
Where?
Were you charged by the police?
Yes, for obstructing the execution of a High Court writ.
So and they're claiming assault.
Yeah, but I've got proceedings in the court, but they've taken action.
Well, no, but it's like Mark says, isn't it? In order for there to be a victim, there has to be harm. Or harm.
Basically they've got to prove some harm.
Yeah.
So, but anyway,
if you didn't touch them,
we can talk about this later. Okay?
Yeah.
But basically, the fundamental point is the state, okay, needs to provide both parties with equal opportunity. Otherwise, there's bias. So the first thing is, immediately, if it takes legal professionals 3 months, it's not unreasonable for you as a layperson to ask for an adjournment of 9 months, 3 times the length. So the first thing you do is you ask for an adjournment for 9 months. And then you can start to go through it.
Also, Mark, Randall's case, they just handed a bunch of loose paper, which was partly dropped on the floor, so you couldn't confirm it.
Okay, so let's just talk about this now. This is an important point that Calvin makes, the four-corner rule. Okay, what's the four-corner rule? Here's an example of the four-corner rule. Okay, it's not a box within a box within a piece of paper. This is the four-corner rule. What is all in there? Okay, that's the four-corner rule. So it needs to be a bound document, or at least a document which lists every part of that. Okay, so that you can verify. So if you look at the way that I do the manual, I don't know, is that a manual?
Yeah.
Okay, page something of. So you can flick through, you know how many pages there are in total, and you can see if you're missing a page. Okay, so that can be on loose paper and doesn't need to be physically bound. However, it tells you on each page so that you can see if you can have all the documents, all the papers.
I don't have that.
Right. So basically, you need disclosure of all the evidence. What have they declared? And you need to be able to verify that you've got everything that they claim they've given you. So fundamentally it's disclosure. And we'll talk about disclosure tomorrow. Okay, so again, with the Sentencing Act 2020, what it's saying is, based upon the evidence before the court, if there's no evidence of harm, there can be no fine. That's what it's saying, right? Because to prove intent is very difficult. Okay, and it's even worse, might foreseeably, because everything is possible. You yourself, Your Honour, could have done that. What's the only difference between you, why are you not being fined? Okay, simple. Okay, so trial by jury, the main issues, okay, is that they don't actually understand what they're meant to be doing. Each individual juror should be following their conscience, which dictates right from wrong. Okay? But if you've got 12 people in a room and you've got one persuasive person, they can sway everybody else. through rationality rather than conscience. Okay? So that's one massive problem I have with it. When you look through the history of trial by jury, go back a couple thousand years, a unanimous decision was thrown out for precisely that reason. A unanimous decision, the risk of it having somebody being persuasive and persuading people's conscience was too high. Because based on the normal distribution curve, you're always going to get one or two juries on either extreme. Okay? The other thing, like I've said, there's no logic and reason as to it. And there's no obligation on the jurors to explain how they reached their decision. So how the hell can you appeal against something you have no idea of? There's no rationality there. You can't. Okay? So trial by jury, you've got to be careful with this stuff. I'm not really a fan of it, but as a solution, and with the voluntary association that I'm trying to put together, the concept behind the public dispute resolution is to try and overcome these inherent problems which history has shown us can be a problem. So with that, because people are, I'm a minority, okay, and I perfectly accept it, and there's validity to both sides of the argument. But basically, the jury should be inquisitorial. What is important is that the claimant is understood by the jury as to what their problem is. And therefore, in order to satisfy yourself, there needs to be interaction with the jury. Okay? And so the jury should be inquisitorial. Once the claimant is satisfied that the jury understands their claim, they independently reach their conclusion. So you don't have any of this in secret round the back. And then they determine whether harm has been caused. If harm's been caused, then it moves on to the next phase of the trial. They listen to the other side of the story. Again, inquisitorial. Again, retire independently, reach their conclusion, and come back with it. And then the claimant, the harmed party, must express what remedy they want to return to the peace. So it's not the state saying, for speeding it's 15 quid or 50 quid or whatever. Okay? The person that's been harmed must say, this is what I want to return to peace, explain why they feel it's reasonable. The defendant explains why they feel it's unreasonable, and the jury just makes their decision, and you just average the thing out. But somehow, there needs to be some rationality to it, and we need to overcome the whole concept of the problem of trial by jury. So, but that is really a philosophical thing more than a real issue. But once you're familiar with the way that it works and understand this concept of point by point, you'll see that there's actually very simple ways to resolve dispute. Okay, next thing then is criminal matters versus civil matters. Really, really simple. It depends what Parliament decides. That's it. That's the only difference. Okay? They just, I know this is criminal. No, that's not criminal. That's it. Simple. In theory, it's if you're creating a harm to society as a general, as a whole, as opposed to any individual. However, like you've pointed out there, all right, there must be a harmed party. How can your actions have harmed the state? The state is a fiction of law. It doesn't exist, it's not real. It's impossible to harm something that doesn't exist. Okay? So this concept of criminal versus civil, utter crap. All right? It's just revenue generation and stuff like that. And like I've given you the example about the mother forgiving as the harmed party, all right? It's only the harmed party which can decide. Nobody else has the right to decide. So basically, in theory, okay, criminal matters, wrongs against society, trying to modify people's behaviour through threats and intimidation fundamentally. But what's different is criminal matters are meant to be beyond reasonable doubt, as opposed to civil matters which are on the balance of probability. So the burden of proof is much higher in criminal matters than in civil matters. So, like I say, merely it's a definition by government. Now, okay, so let's just quickly have a look about what is reasonable, and I'm sorry, what's a balance of probabilities thing. So, look at SARS. Okay, what's the claim? I think a protagonist exists. What's the probability of that? 50-50. Either it exists or it doesn't. Nothing else is possible. That it causes unique harm. 50-50. Either it does cause unique harm or it doesn't. That it's transmissible. Either it does or doesn't. So for the claim to start off on a balance of probabilities, you've got 50% of 50%, which is 25%, and 50% of 25% is 12.5%. Does it sound like it's possible? No, it requires further investigation. So any claim with that, on the balance of probabilities, is utter bullshit. It needs to be further investigated. Okay? So anybody that buys that nonsense should automatically do that calculation. Okay, is it very likely? Does it sound right? Okay, but most of us instinctively know this. But this is the way that you work out balance of probability. But essentially, without a harmed party, there is no lawful claim. And therefore, ultimately, it boils down to everything actually is a civil matter.
So Mark, mustn't then the harmed party make the claim?
Okay, the harmed party, what they do is they have authorised the CPS to act on their part. Okay? And so the CPS is now representing them in this matter. Okay? So basically the CPS needs to prove that that party's been harmed. Okay? So I don't know, what harm are they claiming?
I obstructed the High Court writ.
And what harm is there from that?
I think the piece of paper must have been harmed.
Okay.
They've stolen your time, which you can never get back if anyone came against your time.
Now maybe they may have been harmed in that they need to come back again to enforce it. Okay. So, but I don't know what they're claiming against.
Yeah.
Okay. But so what is the potential penalties?
They said it's a possible indictment charge.
So potential jail time.
Yeah.
But again, okay, let's talk about it separate. I just want to try and get through some more stuff. But basically, they need to prove harm, and with the Sentencing Act 2020, whatever the remedy that they propose to give the harmed party must be provable in evidence. If they can't evidence actual harm, and it needs to be in proportion. Okay? So, but the Sentencing Act 2020, you want to go through that part of it. Okay. Anybody got any questions on that so far?
When you did the 50% and 50% and 50%,
Yep.
why isn't it proving each factor more than 50? Why did you multiply them rather than...
There's only, no. Because it's the cumulative probability, the cumulative balance of probabilities. So if there's a 50-50 chance here, in step one, it exists or it doesn't.
Yeah.
So that there's got a 50% probability of being true. Then, for 1 and 2 being true, you multiply them. Okay?
Yeah.
So it must be joined by and.
Correct.
Right.
So for it to have a legitimate aim, those 3 things must be proven.
Yeah.
If those three things can't be proven, it's not got a legitimate aim on the balance of probabilities, therefore it's unlawful because it's irrational.
How the blazes have they ever got away with what they're doing?
Because nobody's challenged them. Those who don't stand on their rights have none. Okay? And this is why you, the individual, has the power to stop crap like this ever happening again. You know? Honestly, it's this
Yeah, but-
simple.
I'm expressing here the responsibility in all this
Yeah.
on the judiciary. They must know that what they're doing. It's like, for example,
But the
that-
judiciary's got a problem. Okay? If I've got two idiots talking a load of crap, how can I do the right thing? Because I can't impose my will. I'm meant to be a neutral party. So if I've got two idiots. So look at the appeal court, okay? It's online. You can watch this. Look at the Simon Dolan appeal. My God, what a bunch of incompetence. You could see the judge wanting to pull his hair out. He was getting frustrated with these idiots. Okay, they had the barrister standing here with two of their legal whatever's behind them. They couldn't even direct the judge to the right page on the second or third time. What you've got is the barrister saying, okay, page 68, and then tug, tug, tug. Sorry, page 62, tug, tug, tug. Oh, page 54. This is going on with these legal professionals, and you can see the judge just like not losing his temper the way that he didn't lose his temper. But when you got idiots like this, forget it, it ain't going to work.
But okay, but then isn't it the judge who then listed all the letters of the alphabet except E,
Correct.
which must have been an intentional omission?
You're making a presumption. All that they can you can presume is it's an honest mistake. You won't ever get anywhere beyond that.
So you can't, because, you know, in
However-
say your balance of probabilities is that A, B, C, D, E follows B.
Correct.
It's as simple as that.
Okay,
That's 100%.
but now try and prove it.
Unless you've got a tape of him
You
in the
can't.
bar afterwards saying
Yeah.
he deliberately stepped out.
Yeah. Okay, the next one's important, and this one here we've been starting to use with the public access to courts. All right. So now I've said to you, I think I've said, okay, jack of all trades, master of one. No, sorry,
None.
master of none is
I said-
better than master of one.
Yeah.
Okay? So basically, what that's saying is, if you're a generalist, a common sensor, it's far better than being a specialist. Okay? And it's only like 6 weeks ago or something that somebody put in that last sentence to me, and all of a sudden it makes sense. So if we say jack of all trades,
Master of none.
master of none.
Is better
If you
than-
just take that, there, what it's saying is, okay, it's crap being a jack of all trades, you're better off being a master of one.
Yeah.
But when you add in the last sentence, it tells you, hey, listen, that's the wrong way you're interpreting it. So we're all familiar, not only must justice be done, it must be seen to be done, yeah? Okay? The last sentence, which you don't know, is nothing is to be done which creates even a suspicion. Okay, even a suspicion that there has been an improper interference with the course of justice. Even a suspicion. Okay? All of a sudden, that makes that into an incredibly powerful tool that we've got at our disposal. So anything which raises even a suspicion, okay, means there's an injustice. So, what this is saying is, if your conscience is saying there's something wrong with it, there is something wrong with it and it needs to be investigated. Okay, so it's going against the fundamental principles of public access. So, what we're doing is, with this, basically this here is getting us into public galleries now. People, if you walk into the courts and security starts with their bullshit, no, you can't get access to the courts because of COVID or this, that, or the other, or whatever, doesn't matter. Okay? You just show them this. If they deny you public access, they now have biased and they now have voided the order. What comes out of it is void. Go back to Lord Mansfield, 1762. No inequity can be used as a defence or cause of action. Okay? So this is incredibly powerful. And so the open access to justice doesn't only include, though, the actual physical being in the public gallery. You have every right to see every document because it's a public dispute resolution, and you have a duty to ensure that, an obligation to ensure that nobody's peace is being breached. And hence, you have the right to see every document. And that was ruled, it's a long case name, okay, it's in the footnotes, the name of it. But basically what this case says is, absolutely every piece of paper that's part of that court record, we all can see it. Okay?
Does that apply to the family courts as well, where their child's...
Right, basically, yes, it does apply to the family courts. However, there's the concern that you don't want to unduly influence, I don't know, not the right word, but there's no need for the identity of the child to be named.
Mm.
Okay, so therefore it's fair and reasonable that name is redacted.
Yeah.
However, with the liability orders from the council tax, there's no reason for them to redact anything. Why? Because it's a public judgment, and all judgments must be publicly available. So when the council started to redact this and only send your little name, that there is bullshit. Okay? So we have full access to it, and we need to stand on these rights. And so that there's a Supreme Court judgment. Again, the highest court, all lower courts are bound by this precedent. They have no choice but to abide by this. But if we don't stand on these rights, because this is our right, if we don't come to them and say, here's my right, now do your job, okay, we don't get it. So we are the ones that are responsible for upholding the rule of law. We can't blame them and say, oh, well, they're a bunch of Freemasons, or they're this, or they're corrupt, or that. Sorry, we're the problem. We are not standing on our rights. And it's human nature to do as much as possible for as little as possible. So if we let them get away with this today, tomorrow they'll do that, then they'll do that, and they'll keep on coming. Until somebody says, enough's enough. Okay? So we need to stop turning a blind eye, stand up for the weakest in society, and start to stand on our rights. It takes a few good men to do nothing for tyranny to prevail. We're all familiar with that. So what's the mirror say? It takes a few good people to do something for tyranny to fail. It doesn't take many of us. Okay? Right. Okay. So that just basically goes into detail the case law that we have access to all documents. Right, people have been putting in, and with the council tax we started with putting in DSRs to the court. There's a much easier way to do this. Okay, the courts are excluded from the Data Protection Act. Okay, the easy way to do it is to use the court's own rules. Because the court's own rules, section 66A, tells you, ask us, pay the fee, and we give you. Okay? So, we don't need to mess around with data protection. We simply quote Magistrates Court Rules, section 66A, open justice principle, blah, 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 blah. Officers of court must deal with cases in public, i.e. public access, allow public hearings to be reported to the public, and the rights of persons affected by a directional order made or warrant issued by the court to understand why the decision was made. So what have they been doing with us with council tax? Oh, we rule in favour of the council. Well, based upon the evidence, how the hell have you reached that conclusion? I need you now to explain how you reached your decision. We've not been doing that. You see where we failed there, Paul?
Sorry?
You see where we failed there?
Yes.
We should have used this in accordance with section 66A 1C, explain why you disregarded the Bill of Rights.
Yeah.
Okay? So with Paul's, what did we do in the council tax? Okay, what should happen, and we'll go through this tomorrow. There's the due process, all right? So basically, that there, equal treatment bench book, was pulled up in front of them. And we'll talk about this tomorrow, okay, and go through in detail. But essentially, we brought up the Bill of Rights, Coronation Oath Act, and the Act of Settlement 1700. The Local Government Finance Act has no authority from the source authority, i.e. it's ultra-virus. Therefore, the court needed to explain to us, we've put you with the knowledge of these, even as litigants in person. You needed to weigh up the evidence. Okay? How on earth have you determined that this here is a legal document? Because what we've said is, it's got no authority. It's illegal by their own rules. But again, at the time, I hadn't got this far with my research, but now we can sit and ask them the question. They can't diss us anymore.
No.
Okay? So, all we're doing is using equity. This is equity. Damn hell. Explain how you reached your decision. And if you can't, then up yours. It's irrational and therefore unlawful. So far, we've been through an awful lot about our rights. Okay? So, with this, we now, hopefully you can start to see accountability, how we can get accountability in the courts. Just through a few simple basic concepts. Okay, how are we doing for time? 5 o'clock. Is there, how many people are stopping over or got things to go back to or anything like that?
I'm going back to the
Is it okay if we go on to 5:30?
Yeah, of course.
Yeah? Okay. Right. So remember, and we'll look at contempt of court. Contempt of court is anything which prejudices either party. So, in a council tax issue, who can be prejudiced? Me, if they're making a claim against me. In any matter, it's the respondent that's going to end up providing the remedy. Therefore, they're the only ones that can be prejudiced. The other party cannot be prejudiced. So anything which prejudices your right to self-defend is a contempt of court. And that voids any order that comes out of it. Okay? Why does it void anything? Because if there's an inequity, if there's something wrong, it can't be used as a defence or a cause of action. Lord Mansfield, 1762. Okay? A wrong cannot ever be turned into a right. Simple as. So, recording in courts. Basically, the Criminal Justice Act 1925 basically says, and this is a limitation, okay? It is only a judge of the court or a juror or a witness in or a party to any proceedings before the court. And section 2C says it includes entering or leaving the court room or any building, and there's a £50 fine. Okay, that's what they're telling you, you can't take photographs and stuff like that. But let's just understand the substance behind it. What was the intent behind it? Go back 1925, the vast majority of cases were what? Trial by jury. And if you've got multiple days, okay, you don't want the jury to be prejudiced through somebody's making a report. Because the jury may not necessarily have the power or the comprehension to determine what they evidenced in court, and they could be influenced by what they saw outside of the court. So there is a bit of rationality to it, okay? And so basically, then the 1981 Contempt of Court Act says you can't record except with leave of the court. Okay? The leave is discretionary, and the same thing in the Courts Act 2003. Now, and the Crime and Courts Act 2013. So what they're saying is, if the court grants you permission, okay, then you can record. So the question becomes, how do we overcome this? Now, John Geely, who I've been working with on appeals in the Valuation Tribunal on council tax, he's found something else as well, where basically we're going to try and force the Lord Chancellor to change this. Okay? So let's look at the rationality. We've said already, as the defendant or respondent, you're the only one that can be prejudiced. So, fine. We apply to the court and say, I'm going to be recording to this. Can anybody show reasonable grounds, as I'm the only party that can be prejudiced by this, that, have you got a problem with it? I can't think of one reasonable ground. Anybody can come up with. Okay? So again, we've got to start asking. If we don't ask, we don't get. Once we start getting feedback, then we can start to tackle the substance of them refusing to give us the right to record. Because the magistrates' courts are not courts of record. Therefore, how can I appeal if I don't have a record of what went on there? An accurate record. Because it becomes he says, she says. Forget it, no evidence. Yeah?
My FOI, the Ministry of Justice,
Yeah.
I've got the letter where they said the magistrate's court is a court of record.
Is a court of
Forward me
record.
a copy.
Yeah?
Because, okay, now, okay, they must keep a record of the claim
Yeah.
and the outcome.
Yeah.
Okay? To me, a court of record is a complete transcript of everything that happened.
Correct.
So you're saying that's a court of record?
I've been sending them FOIs just to tease.
So
things
ask
out.
them how we can get the record then. Okay?
Yeah.
And so with it, again it extends to equality. All are equal under the law, nobody is above the law. And available technology. Why on earth must I pay for a transcript if I can record it on my mobile phone and plonk it through a free transcript service on the internet? Why do I have to go and pay hundreds or thousands of pounds to get a full transcript of what went on? That there is in breach of what is actually common law, equal treatment and fairness. I.e., every like situation must be treated with like. And it must be fair. Why? Fundamentals. All are equal under the law, nobody's above the law, as affirmed by the Statute of Monopolies 1623, which says any grant of a privilege is unlawful. Why? Common sense. All are equal under the law, nobody's above the law. So all of this always comes back to the fundamental simplicity of everything. Okay? So we've got to keep coming back to this fundamental simplicity. So you're the only one that can be prejudiced.